public policy, bankruptcy law, consumer law, criminal defense law, family law, and intellectual property law. He is known for his professionalism, sharp-mindedness, and knowledge of law and its intricacies. We are grateful to have you, sir, with us today. Please join me to give a round of applause for sir. I request Abhishek Rao, from NLU Prayagraj, to kindly felicitate sir for his presence. To commence with this session, I respectfully invite Mr. Rahul Tyagi to share his valuable insights on the subject.
A very good morning to all of you. Thank you, Think India, for inviting me here to deliver this keynote lecture on the Pragya Singh Thakur judgment which has come acquitting all of the accused. It's ironical that I represent NIA and this case was prosecuted by NIA. So I'll come to that. It's not a loss, it's a win. I'll explain that to you later on. It's a landmark judgment in the sense it is not a judgment delivered by Supreme Court that it has become binding. It is a judgment by the trial court, which has acquitted all the accused who were accused of those crimes in that case. I'll take you through, I think I have 20 minutes. So in these 20 minutes, I intend to take you through the basic facts of the case and then why this case was acquitted and certain controversies that were associated with this case. And that is why it has become a landmark judgment, because it was kind of a landmark case, a cause célèbre, because a new line of terrorism, a new vein of terrorism was introduced by this case by the government. What is called as the saffron terror. This was the term used by the then Home Minister in 2010, which led to a lot of controversy and initiated a lot of interest in the case, because now India was facing allegedly two kinds of threats, one from the Islamic terrorism, primarily. Of course, there are other strains of terrorism, such as the Khalistan movement, then there is the left-wing extremism. But this was the new thing that had come up and which caught the fancy of the entire nation. It was also very interesting and followed by people because some army officers were also indicted in this case. So I am not sure how many of you would be aware of the basic facts of the case. So I'm assuming not everyone would be aware of it. So I'm just taking you through the basics of this case. So this case relates to a bomb blast which happened in 2008 in Malegaon. Malegaon in Maharashtra. Malegaon is a place which has a substantial population of Muslims. The bomb blast took place near a masjid on the day of the Eid, if I am not wrong, and it killed 6 people, 101 injured. The case was initially investigated by the anti-terror squad of Maharashtra. Then it was taken over a few years later in 2011 by NIA for further investigation, and then the investigation concluded practically in 2016. So for 10 years, the investigation went on. The case, as the investigating agencies put forth before the court, was that the case pertains to the bomb blast, but the persons who were found to be guilty or found to be involved in assembling the bomb and planting it at the place of incidents, they were never caught. They were never caught. So basically, the case that was tried was for conspiracy, because the persons who were actual perpetrators were never caught. They are still absconding. I'll give their details a little bit later. So the narrative constructed by the ATS, Maharashtra, and later inherited by my agency, National Investigation Agency, was ambitious in its scope. It alleged a counter-terror conspiracy, a plot hatched not by foreign adversaries, but our own Indian citizens, the Hindus, to avenge Islamic attacks on Hindu temples. That was the narrative that was built in this case. The prosecution alleged that a conspiracy among Hindu nationalists to bomb a Muslim-dominated area in Malegaon on September 29, 2008, during Ramzan, killed 6 and injured 101 using improvised explosive device using RDX. And that was planted in a motorcycle, an LML motorcycle, or I think probably it was a scooter. Now, the case was that these persons who are accused in this were part of an organization called Abhinav Bharat, and it was also called the Abhinav Bharat Conspiracy. The agencies argued that the accused formed a hardline organization called Abhinav Bharat, which was a registered society or a trust. I'm not too sure about whether it was a trust or a society, but it was an incorporated entity which expressed intent of establishing a Hindu Rashtra through violent means. They alleged that meetings were held in Bhopal, Faridabad, and Nasik, where the conspiracy was crystallized and formed, where specifically the prosecution claimed that Pragya Singh Thakur provided the logistical support, her LML Freedom motorcycle, to transport explosives, against Lieutenant Colonel Purohit, who also became quite famous, was supposed to have organized the RDX from his contacts in Kashmir. And there were some other allied persons also who were helping in this conspiracies, taking part in organizing this attack. Some of them were Ramesh Upadhyay. He attended meetings. Samir Kulkarni, who attended meetings in Pachmadi. Ajay Rahirkar, who was the treasurer of Abhinav Bharat. He was alleged to have collected funds for Abhinav Bharat and then giving those funds for these terror activities. These were around 20 odd lakhs of rupees were there. 4.75 lakhs were given for the specially, and 2.5 lakhs to A9 were given specially for this purpose. So this is the basic case that was built. Now, Abhinav Bharat, curiously, was the organization which was organizing all of this. It was never made an accused. It could have been made an accused. In this case, not only, I'll tell you which sections were invoked in this case. So basically, IPC section 302, which is murder, 307, 326, 324, 427, 153A, 120B, and then section 1617 of UAPA UAPA is the anti-terror law. So I'm not sure if you are aware. I'll digress here for a moment. Offense of terrorism is also like any other offense. You commit a murder, it is punishable under 302 in IPC. When organized criminals commit a murder, they are prosecuted under Makoka. And when you are committing a murder or a violent incident for a particular purpose, which is a political purpose, to break the sovereignty and integrity of India, or to cause secession or cession of Indian entity, then it is prosecuted under the UAPA. So basically, same offense, depending on the intent, is treated and prosecuted under various offenses. You got angry with your friend and said he misbehaved with me, you commit a murder, you are a simple 302 murder. If you are a member of Dawood gang, you are extorting money and commit murder for that, then it is Makoka. And if you are doing it for political purposes like these organizations, like Lashkar-e-Taiba or those banned organizations under UAPA, then it is under the anti-terror laws. Interestingly, in this case, Makoka was also involved. Now, Makoka is a statute which punishes organized criminals who have formed a gang and they're trying to make money by committing offenses. Now, why was Makoka invoked in this? And Makoka was finally set aside that you cannot invoke Makoka in this case by the Supreme Court. And that had a very interesting fallout on this case. So under Makoka, a police officer can record a confession, and it is admissible evidence. It is not so under UAPA, it is not so under Indian Evidence Act. So to deal with hardened criminals, you can get extract confessions, and that will be permissible to be used in evidence. So the most of the case that was built around this case was based on the Makoka confessions. A police officer writes down the confession while the accused is in custody, and that is admissible. So that was the reason why Makoka, I think, was also invoked, because otherwise they could not have brought this kind of evidence into a court. They had to invoke Makoka only for this purpose, because the police officer could record whatever they wanted. And when the Makoka fell, the entire case fell down because there was practically no other evidence except based on these confessions. Now, the other thing that I wanted to point out in this case is, so finally, the main accused who devised the bomb, who planted the bomb, they have not been found even today. They are all absconding. So it was only the case of conspiracy that was tried in this case, and I think all of you must read this judgment. Why you should read this judgment? It is a 1,000 and odd pages judgment. I find that the quality of judgment is very good. Why it is good? Because it is very rarely you will find a judgment of trial court of this quality. If you read this judgment, practically you will know the basic nuances of all the relevant judgments that are used in a criminal trial. All of them, I was going through these judgments, whether it is relating to Evidence Act, whether it is relating to procedure, whether it is relating to Makoka, whether it is relating to UAPA, how the evidence is to be appreciated, what are the different stages, everything is so beautifully covered. It's a very good digest of criminal judgments that you must all know. Even if you don't want to read all of it, just take out those judgments that are mentioned in this judgment and then read them. It'll take you a very long way in your practice, especially on the criminal side. So finally, the interesting points that have been noted by the court in the judgment are that from the day one, the investigating agencies had formed a theory, and only one theory, and they were convinced with that theory, and then they started finding evidence to justify that theory. This is like putting the cart before the horse. So you decide, okay, I have come to the conclusion that this person is guilty, and now I will find evidence to support this conclusion. Whereas investigation is exactly its opposite. You collect evidence, then you analyze it, then you develop counter theories. Okay, who else could have done it? And then you rule out those counter theories and then come to a conclusion, okay, this is the only person who could have committed this crime. But a theory was formed that there was a kind of a organization which had come up, which is taking revenge for the Islamic acts of terror in this country. And then they said, okay, because I think what happened was, they started with this theory, this bomb blast has happened in a Muslim-dominated area, so it has to be done by the Hindus. That is how this whole thing started, according to me. That is my guess. I was not privy to the investigation, but this is how it started. What they forgot, and I think what we have come to notice very recently is, what if it was being done by the residents of that area? It was an explosion which they never intended to take place. It was an improvised explosive device which was being prepared and was about to be taken somewhere else. And maybe it was an unintended explosion that happened there, which has happened in Delhi bomb blast case also. They were trying to transport because they were fearing that somebody is going to come and raid them. And then they exploded the device. So these that is the whole, what an investigation agency has to do is collect evidence, forensically examine it, examine whether it is admissible, and then come to a conclusion. Here it was completely opposite. And that is the reason for the undoing of their case also. So the court has noticed these facts and court has held. See, you started with a theory, you were predetermined to come to a conclusion, and then you fit those loose pieces into a narrative, and then you have come here, and therefore you could not prove your cases. And all their case was based on somebody coming and saying, okay, I heard them saying this, I attended this meeting, I was passing by, I could hear them saying this. So this kind of oral testimonies were there, and unfortunately, when these witnesses came to witness box, they refused to say that we never made these statements. Some said these statements were coerced from us. So that is another finding that has come in this judgment, that it seems that the investigating agencies were hell-bent upon proving a particular theory, and their evidence was tailored, manufactured to that extent. So the court gave positive findings on the aspect, yes, their bomb blast took place, these people died, but the persons who was arraigned as accused in this case, they had nothing to do with this. This is what the conclusion came, because the investigating agency could never bring to court the evidence that was required to prove their case. So I was just discussing with Ayush, what is a trial? We were discussing what is it. A trial is nothing. What is a trial? Trial is a police officer goes to court and says, see, this event happened, this crime happened, I have investigated this, I have found people who are saying that these people committed these offenses. So they must be now tried, and we will lead this evidence. Court says, okay, if you have collected this evidence, very good, that this shows that these people are involved in this crime, so bring those people who have said this to you. Then begins the trial, and those people are called into the witness box. They come and say, no, we never said this. This is wrong. What is written in this, what was presented to you during the investigation and during the pre-trial stage by the investigating agency, we don't support this. And then the judge turns to the prosecution, says, you were saying these people have told you this, they will come and say they are not supporting your case. I'm throwing out your case. This is exactly what happened here. This is exactly what happened here. Trial is simply this, okay, you are saying somebody has committed this, get that evidence in court and let them say it before us, and let them face cross-examination. The witnesses could not. First, they did not support what was stated by the police, that they have made these statements. Then those who partially supported, they could not stand the test of cross-examination. So basically it turned out it was a false case. Now, there are 3 or 4 issues that I find why this case is a landmark case. The judges are human beings, the investigators are human beings, and they are influenced by certain forces. Media is one of those forces, and the political dispensation of that day is also one of those forces. You have to understand this case. Nothing happens in vacuum. There is a context, there is a history, there are events happening around it. In 2008, when this bomb blast took place, it was not that big a thing. In November 2008, the Mumbai attacks took place in November, and hundreds of people were killed. And the government of that day came under a lot of fire that you were very, very weak in dealing with terrorism. And this criticism was well founded also, because I'll wait here for a moment and please allow me to digress. Till 1985 or 84, there was no anti-terror legislation in India. When Indira Gandhi was murdered by the Khalistanis, then they brought TADA. TADA was grossly abused. That was the view at that point of time. So therefore, they repealed TADA, and on books remained no anti-terror legislation at that point of time. Then happened those some other terrorist attacks took place, and therefore they brought in POTO. POTO was the Prevention of Terrorism ordinance. That also happened because of a particular incident that had taken place, because then everybody said, you remove Tada, now there is nothing left. So they had to bring in Poto, then Pota was brought in, then Pota was abused, Pota was again repealed. At around 2008, when the Mumbai attacks took place, there was no legislation on the books which could deal with terrorism as a specific species of crime. So there was a lot of criticism. As a result of this criticism and this lacunae, the government of the day introduced two legislations. One was NIA Act. NIA was created to deal with these kind of terrorism acts, and they also introduced practically all the provisions of POTA into UAPA. UAPA was Unlawful Activities Prevention Act. It has been there since 1967. It never dealt with the terrorist acts, but it dealt with the subversive political activities. So in that, in 2008, terrorism was made a specific offense, and all the slightly revised provisions of POTA were introduced in here. Now, this was a very, I would feel that somebody who has repealed these, saying that these are not required, and something as big as Mumbai attacks happens, so then you have to justify it. And you had to eat crow because you had to reintroduce these legislations into the book. So to deflect the narrative, I think this canard of saffron terrorism was introduced. This was introduced so that we can deflect. So terrorism has no religion, which I also believe it has no religion. But there are forces outside India which are promoting a certain kind of terrorism in India, and ISIS is one of the biggest threats. I'm doing a lot of cases. Some other organizations also on religious lines were committing certain activities which were totally prejudicial. So I think one of the reasons was also because there is a particular view which is seen as supporting a particular community. Then there's another community which is saying you are supporting them, they are committing terrorism. So I think to balance this kind of thing, this canard of saffron terrorism was introduced. So the agencies which were investigating, there was a kind of a message that you have to do a certain thing. And then the media, the second force which impacts the judges, the investigators, and a lot of people is media. There was also a different kind of narrative being propagated at that time that, okay, saffron terrorism is a reality, it is happening, this has happened, that has happened, nothing has happened. So now, finally, this ghost of saffron terrorism has been, for the time being, buried by this judgment. I am saying for the time being because obviously there would be appeals in the appellate forums. Already, Ayush was informing me that an appeal has been filed by a victim in the High Court. We don't know what will be the fate of that appeal. Appeal is a continuation of trial, so they can completely reverse. They can do something. They can affirm this. Then it will not come to rest. It will go to Supreme Court. I am 100% sure these kind of contentious cases will travel to Supreme Court. So finally, the quietus, the rest will come when it reaches Supreme Court. But after going through the judgment, I think it is one of the best trial court judgment that I have seen in recent times. Very balanced, sans any hyperbole, analyzes the evidence in a very scientific manner, applies the law, and has come to the right conclusion that it was a totally unnecessary prosecution that had taken place. Now, a question comes, and this is a question which I would like to leave with all of you. When the court comes to a conclusion that the investigation was not only shoddy, it was also tailored to frame particular people, then what should be done to those investigators? Should they be punished? Or how would you recompense the people who stayed for so many years inside jail? I think time has come in India for the courts and the judges to take notice that these kind of malicious prosecutions, I would not say that the prosecutor has no role in this, I would not say that the investigators or the uh, people who were the complainants should be punished criminally, but I think a greater deterrent, and there are provisions for that, but the greater deterrent would be like it happens in the US. If state prosecutes someone and it is found to be false and it is found to be tainted to the extent that there was a deliberate intent to overlook other suspects and to just frame them, then heavy financial cost should be imposed. If such a thing had happened in US, I am 100% sure Pragya Singh Thakur and all the other co-accused would have been compensated with the damages of not less than $100 million each. In billions of dollars, they sometimes to send a message. So now I represent NIA and I am a defense counsel also. I am a prosecutor also. The good part of being a prosecutor, he never loses a case. Never. You know why? Because it is not the duty of the prosecutors to secure a conviction. It is the duty of the prosecutor to lay down all the material before the court so that court can arrive at the truth. So prosecutor is the only person whose duty is to ensure that the truth is arrived at. And I'm sure the prosecutor in this case, I don't know what happened. There were some controversies about that also. But I think the truth has finally been arrived. And I must congratulate the prosecutor who helped in getting a acquittal for all the accused. Some of them were army men. It was really sad to see them languish in jail after serving the country. So it is a judgment that should be welcomed. It is a judgment that should be stayed, and it is a judgment which should serve as a reminder to the prosecution agencies, to the investigating agencies, that please don't get swayed by the politics of the day, by the media narratives. You just do your job, collect evidence, come to a conclusion which is rational, which is within the four square boundaries of law, and punish if you find they are to be punished. The travesty of this, according to me, is 17 years have been spent. Innocent people have finally been acquitted. But what about the real culprits? Who committed this dastardly act, which resulted in death of 6 Indian citizens and 101 people were injured? Who is going to give them justice? What should be done? Should a further investigation be done? But what will be the point of a further investigation? After 17 years, you will find no evidence left. No court is going to accept this. That is the saddest part, that the victims have not got justice. And this even sadder part is those victims think that these are the monsters who did this and they have been let off. What they don't realize is that the real culprits in this narrative of politics and media coverage were never found, never investigated, and that's the saddest part. So I think I'll conclude. My 20 minutes are over. So my friend is smiling at me, saying, yes, you have, I think, went over the time limit, which lawyers are used to do. So I'll call it a rest. I would really welcome any questions that you have on any subject. Not right now. Right now, questions after. So my friend, who's the coordinator, who's the moderator, he says it has to be towards the end. Most welcome to answer ask any question. I'll be happy to answer.
Thanks a lot, sir, for your insightful and illuminating address. We can have the Q&A session at the last of this session, okay? I now invite Mr. Ayush Anand to address the gathering and share his insights upon the key issues of the case.
Thank you to the Think India team who has considered me capable enough to put my words regarding this judgment. I'm honored to share dais with Rahul sir, who is a very prominent prosecutor and very expert advocate here in Delhi for conducting trials, and he was dealing with such cases for a long period of time. But before starting my views on this case, I want to make this session an interactive one. I am the least experienced person among the distinguished panelists which you are gathered here to hear. So I want to make this session interactive because I can understand people are anxious to ask questions. So if we have a separate handset, then I want to start my uh, view with certain basic questions to you. So do we have handset? Handset for the audience?
Yes.
Ah. Can you please tell someone to be there? So, as sir has said in the starting of this, in his lecture itself, this is a symposium for landmark cases of 2025, and this is a trial court judgment. Then, why this case, this trial court judgment, has been included in this national symposium? So, I want to ask this question from you. So, what do you think is the main reason behind selection of this case as a landmark case, despite of it being only a trial court judgment, for to deliberate upon here in this gathering? Do any one of you have any idea regarding this? And before that, I just want to have clarity regarding my audience, before which I am speaking. Uh, just raise the hands who are the students, law students, and who are the practicing advocates in initial years. So majority of you are the students of law. So yes, what do you think? Why you are a practicing advocate or a scholar? Yes, sir. Tell me, why do you think we have selected this case for this national symposium of landmark cases? Understand. 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 Now, just a caveat. You have to just give an answer in short, just like an advocate. You don't have to be an activist. You just give me an answer as an advocate. Or you may be a defense advocate or on the side of prosecution. Apart from this, anybody has any idea why we have selected this case? Why they think India has selected this case? Yes, I have taken your point. If those people who are audible enough, so they can speak without mic also.
I think the idea in law is that 1,000 accused can be left, but one innocent shouldn't be punished and tried. So maybe that is the core.
Understand. Understand. Anyone else? Anyone else? Okay. So, sir, you are also right. You are also right. Rest of students have no idea about it. So, you have a question? Yes. If you are audible, you can speak. Yes. Yes. Great. So this case revolves around the events which were happening during the year 2006 till 2012. This incident was of 2008. And in 2008, this blast happened. At that time, I guess all of you must be in school itself. I just started my graduation in some different stream. So at that particular time, if you see the narratives which sir was saying in different newspapers, for those 4-5 years, there were blasts happening randomly across India, in temples, in railway stations, in dargah, in trains, everywhere there is blast. Ajmer blast, Jaipur blast. This was Malegaon blast. There's so many blasts. So in 2008, just before that, but as sir said, POTA has been removed because in Vajpayee government, POTA has been used for certain terror activities, subversive activities in Tamil Nadu. So there was political narrative that this POTA is draconian, we will remove it. In 2005, when UPA government came, POTA has been removed. And due to the minority appeasement politics, a certain relaxation were given to certain elements. and they started feeling they can do anything. Blasts were happening. And there's an allegation to the government, against the government, by the certain fraction of voters, which they conceive that they are my voters, that again the police and all these authorities are doing the same thing. So first problem with this case, to appease the minority, they have started building the theory of Hindu terror. If you go into the newspaper of 2008, there are, before this Malegaon blast, there was Samjhauta blast, and the most important factor, A9 in this case. Have you all have this judgment in your mobile or iPad? So you should read this judgment. So A9, Colonel Purohit, he was a witness. He was being tried to made a witness in Samjhauta blast. He's being forced, or he's being conveyed a message, you give certain statement in certain manner, we want to do certain things. He has refused, so he has made an accused in this case. Now, what was that thing? This case is landmark because this entire incident has been converted into political conspiracy, then political narrative, and thereafter weaponization of this incident to settle the score with certain political persons in the country. At that time, this incident had been used directly against the present ruling dispensation, and a nationalist organization has been directly alleged, has been involved in this incident without now, which is very clear now, without any evidence. So, to appease certain fraction of minority, no, you are not the only terrorist. There are majority also who are also doing this terror kind of activity. So we are taking action against both. We are also taking action against Simi, but we are also taking action against certain nationalist ideological forces also. To build that grand narrative, they have started this investigation with this premeditated design, which Sir has expressly narrated, which I just want to read one quote of the judgment, which will clear. And this is para number 582 of the trial court judgment. This statement is in relation to the discovery and the link of LML Freedom motorcycle with Pragya Singh Thakur. I'll come to several interesting facts, because as a trial court and our main duty is scrutiny of facts. So trial court, what trial court says in its finding, there are details discussion. Admittedly, PI is not examined by prosecution. Therefore, his testimony does not inspire confidence about inquiry, investigation during that particular period. Considering all the aforesaid aspects, it also gives rise to inference that getting the knowledge of entire numbers prior to examination by expert is nothing but creation of own pre-decided story and followed the predetermined path of investigation. Why court is saying this? So they say there's a blast in the motorcycle. That LML Freedom motorcycle was used to create this blast. So this bike belongs to whom? So the investigating agency ATS sends the details of the number, chassis number and engine number to LML company. LML company corresponds to the dealer. Then their dealer then verified. So all these information came to ATS on 31st October 2008. 31st December 2008. And admittedly, in this case, Pragya Singh Thakur was illegally detained on 10th October 2008 and arrested on paper. They shown her as an arrested person on, I'll tell you, on 23rd October 2008. So if you have to link Pragya Singh Thakur with LML motorcycle, then first you have to receive certain official communication that this LML motorcycle belongs to Pragya Singh Thakur. Now on that aspect, whether that engine number belongs to that motorcycle which has been found at the site of occurrence, place of occurrence, that is also doubtful. But even on a demurrer, if we assume that that motorcycle belongs to Pragya Singh Thakur, that fact got clarification by the LML and the concerned dealer on 31st October. But they arrested Pragya Singh Thakur much before that, on 10th October itself. Why it has happened? So, therefore, this trial court judge it's saying in his judgment that investigation started with this very premeditated design. Look, this blast has happened just in front of Simi office in Malegaon, so it must have been done by certain Hindu extremist group, and therefore they have narrated this story of Hindu terror. When you see when this incident happened on 29/9/2008. So before going to facts of the case, just I want to clarify, or I want to make myself very clear why this case is landmark. Because of that grand political narrative, this case was being used to completely dismantle a nationalist organization just to appease certain minimal minority appeasement politics and fractions. Suppose, and there was even direction to arrest RSS chief Mohan Bhagwat at that point of time in 2009, which is also explained in this case. And Sir was saying there are two persons who's the main accused who has never been arrested. Those two persons, Kalsangra and Dange, AA1 and AA2, they have been explained by this person. If you follow this case, former ATS officer Mahboob Mujawwar. He's a very honest Muslim person. And at that point of time, ATS thought that an ATS officer having Muslim name, having big beard, if he goes and arrests RSS chief Mohan Bhagwat, that will be very big win for them, their political narrative. They sent them to Nagpur. He stayed in Nagpur, being a junior but very honest police officer. He scrutinized the evidence and he refused to arrest RSS chief Mohan Bhagwat at that point of time. And in 2009, he has been foisted with false cases of land grabbing and capture of certain apartment. He has been arrested. Then he contested his case. Then he has been acquitted in 2016. Then he made certain statement. Those statement has also been produced before the court in this case. And what he says ATS has sent me there to arrest RSS chief. And those two persons who is still not being arrested, because the person who is ATS is saying they have put that motorcycle there, it's been killed by the ATS and he cannot be found now. So, and because of taking advantage of these two persons which absconded, entire theory and conspiracy has been built upon that they were the conspirator. So this is the context. The kind of impact, if this incident, if the theory of prosecution will be accepted in toto, then its impact can be understood that it can damage the complete harmony of our society. Just to serve a political narrative of the ruling dispensation, entire story has been created. But what happened in this case, after this incident, just after 2 months, Bombay incident happened on 28/11. In 28/11, if you people remember, for the incident of 26/11, Mumbai attack, now Dhurandhar, everybody must have watched that Dhurandhar. So at that time also, just after Bombay terror attack, Hemant Karkare, the chief, who was the main investigator by the ATS in this case, he died in that terror incident. So Digvijay Singh, Congress leader, and certain other Congress leaders, there are certain other communist leaders, certain other Islamist groups, intellectuals, they properly organize a book. And there are certain books also on this topic. They said Mumbai terror attack is also conducted by Hindu groups to take revenge from Hemant Karkare. If our forces not have arrested Ajmal Kasab at that point of time, be sure this incident may also be clubbed with the Malegaon incident. So that was the grand narrative. And when they have started doing such kind of atrocities on the name of anti-terror squad, their squad people started refusing obeying the order of their seniors. And that's how, but they have submitted their charge in 2009. And that's how this incident, they have taken a little backstand. So this is the grand narrative in which, in this context, this judgment becomes important. And they arrested, and incidentally, after Bombay incident, 26/11, 20 November 2008, A11 was arrested, and this was the last arrest. After last arrest, one arrest was happened 2011 also, but for 8 years, 8 years, 2011, 2008 was the last arrest, or the last conspiracy after Bombay terror attack. No arrest was happened, and then, as sir said, because of the pressure, they bring NIA Act, and till 2010, remember this thing. Till 2010, they were behind Swami Asimanand in Samjhauta blast. So they were pressurizing people, A9 Colonel Purohit, all these people to take name of direct that time, who is, I don't want to take names, but top officials, top politicians of BJP and RSS. In that case, that never happened. A9 refused. After waiting that long period of time, then they decided no, only by putting all Pragya Singh Thakur, Colonel Purohit, their politics is not getting served, because no active politician is yet been framed by that UPA government. So in 2011, in the first, I think in April 2011, they have transferred this case to NIA. So in 2008, you have NIA Act, but you waited 3 years, despite knowing this is a terror attack, to transfer it to NIA. So what happened behind the picture is this. Till 2010, they were trying to connect with Samjhauta blast. They failed. Then they bring this Malegaon incident. Then why delay? Then 2011, NIA moved an application to examination of all the witnesses. Allowed judicial examination. Judicial examination was going on, but they were not getting the answers which they think they should get it. So they, after examination of all the witnesses and the accused persons, they again moved an application. No, I want custodial interrogation in this case. They moved an application, and that application got allowed by the trial court. What is the purpose of custodial interrogation? If you are inquiring a person, contradict a person with the evidence, with the you can have two sittings in front. You can easily elucidate who is telling lie, who is telling right thing. Just to again reframe and use this case as a political tool to settle a score. At that 2011, the political situation of this country was very tense. Allegation of huge corruption against Congress, and entire agitation was being led by some other people. So their purpose was to link this after this custodial interrogation to RSS chief and ruling BJP dispensation. It was direct affront. But thankfully, High Court has refused it. High Court has stayed that trial court direction. Now there is no need of custodial interrogation. You have already investigated in judicial custody. Thereafter, they moved to Supreme Court. In Supreme Court, this case delayed up to 4 to 5 years. Then Supreme Court also expressed its views in favor of High Court. They said, no, the Makoka and other provisions, there should be special court, the bail should be decided, and we are not going to interfere it. That's how in 2016, this case went to the special court, and bails has been decided. And then NIA in 2016, because of change in ruling dispensation, for the first time, they have done independent investigation. So this case is landmark to understand how an investigation should not to be done, why an investigation or a case should never be used as a political weapon. And the NIA, and interestingly, the charges submitted by the ATS and the charges submitted by the NIA is strikingly different. In this case, despite of transfer the case to the NIA, ATS again after 2 months submitted a charge sheet, secondary charge sheet. But NIA in 2016 finally submitted secondary charge sheet. In that charge sheet, it says there is no evidence. I can read paragraphs to paragraphs how the entire theory has been debunked. There's one theory, there's two theories of this bomb blast. Just in 5 minutes, I'll just try to explain. One theory says the RDX or improvised explosive device has been put behind the seat or inside dicky of the LML motorcycle. But the motorcycle which has been seized, the kind of in the kind of damage which happened to that motorcycle, judge specifically narrates in its paragraph that it can only happen when a light small powered explosive device just hanged on the handle of that motorcycle, because its petrol tank was intact. There the main steel body of the motorcycle was intact. The motorcycle was just standing beside that motorcycle. There's one small puncture in that petrol tank. So that RDX explosion theory can't be sustained with the kind of evidence which we are getting from the place of occurrence. The entire theory of RDX has been debunked. Then the RDX, Colonel Purohit has took RDX 60 kilogram of RDX from Kashmir in some operation. Then they bring it to his home, then put in the cupboard of his house. That 2 times at ATS at that time 2009 itself went to his house, tried to recover. All FSL reports says there is no trace of RDX. Neither there is any trace of RDX, neither there is any proof at the place of occurrence that RDX was even used. Interestingly, Colonel Purohit was MI operative, military intelligence. So what does military intelligence do? Military intelligence just be with all kind of suspected groups or individuals to gather the information. He also raised this point with there is no sanction. There's Colonel Srivastav in this case, who has been, without following military protocol, directed the custody of Colonel Purohit to ATS. And then ATS committed huge torture in this case, which is well documented in this evidence. Pragya Singh Thakur also complained about the atrocities. I can give you like number of witnesses has been complained about police torture, ATS torture. Immediately before the court also made complaint to NHRC also at that time itself. So entire theory was never proved. RDX was not proved. Motorcycle directly connected with Pragya Singh Thakur not proved. The meeting, there is no single evidence that there was any meeting conspiracy between these people. And the main accused persons who is being alleged that they have kept these motorcycles at the place of occurrence was never arrested. But if you read paragraphs, it's very clear they must have been eliminated. I just want to read this paragraph and thereafter I'll open the dais for questions. Well, but trial court rejected this ATS officer Mahmood's theory because that evidence was not produced before him as a admissible piece of evidence. 313 statement cannot be taken as a record. He was not examined. He was not examined by the NIA also. So on what basis his statement can be relied upon? So court has not relied upon, but court has also not negated the statement or the evidence which has been supplied by the accused person in support of that Mahmood's theory. Now I just want to read one paragraph. There I will leave. Just after this incident, he made a public appearance and gave all these statements to the police regarding this case. Direction to the, if you read the last paragraph, page number 1018, para number 1517, you should read, and I'll supply my note to the organizer of this event. You should also take a reference, but I think this judgment is very good to know how an investigation should be done and should not be done, and how a trial should be done. Both is here in this judgment. And what does it says? It says, it is important to read this here. Now I have to deal with the next contention of learned advocate A10, that ATS officer Mahmood Mujawwar was one of the investigating officers in the present case. Senior ATS officer had given the direction to him to arrest Mr. Mohan Bhagwat, RSS chief, by taking him in custody, whereas their own officer Mahbub Mujawwar had denied to obey such illegal orders, as he did not find any role of Mr. Mohan Bhagwat in the alleged offense. Hence, Mahbub Mujawwar was entangled in a false case by ATS, which was filed before the learned magistrate in Solapur in support of aforesaid submission. Produce some documents. Those are certified copies of application, copy of statement under section 313 CRPC, filed before learned CGM Solapur. Points raised by learned advocate, it is necessary to mention the evidence which came on record pertaining to ATS officer Mehboob Mujawwar. PW 320 ACP Mohan Kulkarni is the chief investigator of the ATS. So ATS chief investigator in cross-examination debunked several theories of the investigation on the ATS itself. Because on the documents, on the record, on the material, nothing was materialized. You can't base your case on the basis of 161 statement. At that time, they were using because of the help of Makoka, which Sir has explained to you. At that time, they were under this belief, we have Makoka. I have applied Makoka here. So whatever I am extracting confession is going to be an admissible evidence. That Makoka has went after the second investigation by the NIA. And Makoka has been dropped. So the case was entirely without even basis of any credible evidence. So then what PW 320 ACP Mohan Kulkarni said. Mohan Kulkarni had denied the suggestion given cross-examination that Mehboob Mujawwar was sent by them to bring one officer, senior office bearer of RSS, but admitted that he was sent to find out, trace out AA1 and AA2. Kalsangra and Dange, Sandeep Dange, he also denied the suggestion that Mehboob Mujawwar publicly declared that the ATS saw dead 2 person and hence his name was not included in the list of witness filed with the charge sheet. So he is admitting this Mahmood person, ATS officer, was sent to Nagpur to arrest these 2 people. That Mahboob is saying, that ATS officer is saying these 2 main accused has been shot dead by the ATS, so that they have just removed the connecting link. So now they can build any story, any fiction over it. Thus, considering the aforesaid evidence, can we say that he was a member of ATS team and investigation in the present case as per direction of his superior officer? There was inquiry with him pertaining to his statement before media and news agency. His name is not listed in witness list and he is not examined as a witness before this court by prosecution side. But prosecution was aware if we bring this person, Mahmood, their entire theory will debunk because a Muslim officer, Muslim ATS officer will completely expose the ATS. So he was not even named as a witness. In this case, several crucial important witnesses was not named as a prosecution witness. Therefore, this trial court judgment was very fine judgment, explicitly details, properly indexed that and on several law points also it summarizes the principles of law on sanction, on delay of FIR, on several aspects very lucidly, that how a trial should be conducted and how a trial court judgment should write his judgment and how an investigating agency should not operate. And in this background of political narrative, because that political narrative still here, it will continue to be here. And we have to be very as a conscious citizen, a law student, always try to defend what is right, what is wrong, what is legal, what is illegal. We should never go with a premeditated design just to satisfy our conscience or to conscience of our masters. We have to go objectively, we have to go by evidence, and we have to strongly object if somebody is trying to prejudice your mind due to his preconceived ideological influence. Okay, thank you very much. Now I am open to question. I think sir is also here. You can ask any questions. Yes, you can also direct, sir, give a mic to sir, to whom you want to ask question.
So, good afternoon to the esteemed panel. I'm Shayan here, final year Institute of Campus of Center. Just wanted to point out the question pertaining to circumstantial evidence in concerns with the Shastra Wilson 894 case of state of Maharashtra, wherein the foundational principles of circumstantial evidence was emphasized upon. So, it is noted that in circumstantial evidence cases dealing with those, considering acts of terrorism, it's quite cumbersome to come up with direct evidentiary value. Therefore, circumstantial evidence is the way to go. And here, the effect of circumstantial evidence was not taken into account. Of course, it's a fine, procedural regulatory deeming case. But how do we, as officers of the court or advocates, deal with this irregularity to bring in circumstantial evidence in connotation with this case or in general aspect? Both the ways. Which in Santa.
The case is like on an earlier basis of human going advocate. It's a very good quote from an English judgment in that. That's I think it's called R versus Wallace. It says, the more the injurious mind, if he has formed a theory, he will pull the circumstances to his theory and convict innocent people. So that caution that has been given in our versus Hollis is true even today. Let me give you an example. You are standing here and speaking about something. Nobody knows what you say. To a certain extent, but political dispensation does not interfere in actual delivery of justice. And of course, we can't speak about human beings. We can't speak about human beings.
Thanks a lot. Thanks a lot, everyone.
This judgment would have come irrespective of the fact whether the dispensation had changed or not changed, because there was absolutely no evidence. Ultimately, that is why it dragged for 70 years. Because you see, when prosecution agencies are, when they have a weak case or they have no case, it is in their interest to drag it as long as possible. It was dragged
evidence which would have led judicial suit.
Just I want to add one sentence. I think in 2009 itself, court has found there is no substance admissible evidence. Discharged. Then High Court sustained it, overturned it. And then, so at that time also court has not agreed to.
Thanks a lot, dignitaries. Thanks a lot, everyone. We really apologize that due to paucity of time, we have to end the session here only. But you can very well ask the questions outside the room. On behalf of Think India and the entire organizing committee, I once again extend our sincere gratitude to both of our distinguished speakers for their time, insights, and invaluable contributions to the important discussion. With this, we formally conclude the second session of the 9th Symposium. Thank you to the participants for their patience and attention throughout the session. We shall now have a lunch break, after which we will reconvene the third session at 3 p.m. Please be seated before the session starts. Thanks a lot, everyone.